I'm Mark Cunningham with Grace Property Management here in Denver, Colorado. As we begin what is our 48th year in business providing full-service property management services to small and medium-sized landlords, I can say that we've never seen a 2-year period where we've had so many new laws coming into our industry, changing the landscape of property management for tenants and landlords both. And a lot of those laws are beginning and they go into impact January 1st of 2026. So we thought we'd take just a quick moment and explain some of the more common misconceptions about these laws. Now, many of these laws are very broad, they are very complicated, they are very far-reaching, but a couple of them to be aware of. So I found this on Facebook. This was a post within a municipality of Denver that someone posted. This wasn't a real estate group. Someone was just posting about some of the new laws that are taking impact. And so they had this post, and there was well over 100 comments, some from landlords saying, gosh, these aren't fair, other from tenant right groups saying that's good to put these things in place, which is fine. But the problem is several of the laws they were referring to are just flat out false and incorrect. We've seen so much misinformation coming out recently on understanding the laws that are in place. Now, I don't think this person is trying to mislead people. What I suspect is they went in and they asked an AI tool to outline some of the more important laws that have been impacted. And so this is what it said. And so let me just offer a couple thoughts around these to make sure you, whether you're a landlord or whether you're a tenant, you understand that there's a lot of misinformation out there, and you can make sure that you understand the laws. So they said there's a bunch of new laws going into effect January 21, 2026, for example, and they listed a couple of them. Number one, security deposit limits. The maximum is now 1 month's rent. Well, that is incorrect. Now, the maximum in Colorado, the maximum a landlord can charge a tenant for the security deposit is 2 months' rent. I realize this is kind of hard to read there. That's the maximum. We should all know that whether you're a landlord or tenant, you cannot go over 2 months' rent. You can't charge it in advance. It can't be due. It can be due in advance of the lease start date, but just that in and of itself opens up a whole nother realm of complexity. But the maximum is not 1 month's rent. It is 2 months' rent. So that statement, the very first thing they're saying, is just incorrect. The second thing they say is there's an installment plan now for tenants to pay the security deposits. Tenants can pay the deposit over at least 6 months. That also is false. There is no law that says tenants have a 6-month period or any type of a window to pay the amount of the security deposits. Landlords can require the security deposit to be paid in full at the time of move-in, and there is no payment plan that's required to be put in place for security deposits to be moving in. Now, the third comment or law they refer to is the deductions to security deposits, tenants' deposits when they move out. What can landlords charge? Now, this changed dramatically because of several new laws that went into place talking about security deposits and what can be charged. They said deductions to security deposits are limited to only non-payment of rent and utilities, cleaning for move-outs, if it's specified, and actual damages beyond normal wear and tear and conditions. That is absolutely true. That is absolutely true. The charges that landlords are allowed to make against a tenant security deposit upon move-out have been greatly reduced. Wear and tear, the legal definition of wear and tear, has been greatly changed. There can be no standardized charges, and this is important, no standardized charges against a tenant's deposit at the time of move out. So you can't say, well, we charge everybody $100 for cleaning, or we charge everybody for carpet cleaning. You can't charge everybody for anything. It has to be specific to that property move out. So if the property needs clean, and the law also has reclassified wear and tear for cleaning and for paint and for carpet, it is very nuanced and it is very complicated. But it has greatly restricted what landlords are able to charge against a tenant's deposit. So that's correct. The next one they reference here is they say move in and move out. When a tenant moves in or moves out of a property, the landlord must allow a walkthrough and provide a move-in checklist to document the condition. That is correct, But there are some conditions around that. Now, that just makes sense. Landlords in Colorado, to my knowledge, have always provided, at least legitimate landlords, have provided tenants a move-in, check-in sheet to record damage that's there. And then when that tenant moves out, that sheet should be referenced and reviewed. And the tenant should only be charged for damage that they bring into the property. That should be pretty honest, but the law codifies that now. And the landlords must allow a pre-move-out walkthrough before the tenant vacates. Now, there's a lot of conditions. For example, the law says that the tenant has to have their furniture out of the property for this to be considered. Well, that's not really rational because the tenant's not going to move their furniture before they move. That's part of the move-in process, and a landlord really can't assess who the charge would be. If there's a hole in the wall, they can't say, well, I don't know who did it yet. Was it here before you moved in? Was it here after you moved in? How much is it going to cost to get repaired? So there's a little bit of nuance there, but landlords must put that in place. These are just 3 examples. There's many, many more. We have a page that we've created on our website where we go through all of the laws prior to 2026 that are now in place for 2026, give an overview to help you as a landlord or a tenant understand your rights as a tenant and your responsibilities as a landlord to navigate. For almost 50 years, we have believed that when property management is performed with integrity and transparency, it's pro-landlord, it's pro-tenant. It's not anti-landlord and it's not anti-tenant. So as long as you as a landlord are following these rules and doing them properly, you should be just fine. And as a tenant, you need to understand your rights, make sure that the lease is proper, which again, jump on our website on that page. We're happy to be a resource if we're able at rentgrace.com. We wish you success in 2026.